There is a lot of noise on social media right now. Some people are calling it misinformation, others are saying it's exaggerated. Questions about large-scale deportation enforcement, ICE activity involving international travelers, and the status of visitors from dozens of countries are circulating widely. I'm not here to amplify rumors. I'm not here to cause unnecessary alarm. What I do is focus on one thing, the law as it is written. And today, I'm going to walk through a specific section of federal immigration law that affects millions of people currently in the United States, many of whom have no idea how uniquely vulnerable their legal position actually is. Because here is what the social media conversation is largely missing. If you, or someone in your family, entered the United States through the Visa Waiver Program using Este authorization, and you are still here beyond your permitted 90-day period, your legal situation is fundamentally different from that of a standard visa overstayer. In many respects, it is significantly more precarious, and understanding precisely why that is may be the most important thing you read or watch today. I'm Edward, and this is U.S. Green Card Signal, where we examine the actual legal frameworks that shape immigration outcomes, not headlines or speculation. I've spent years studying the specific legal provisions that catch people off guard and create life-altering consequences. The goal isn't to frighten you. The goal is to make sure you're informed before a situation arises rather than after. Today I'm going to cover 4 things. First, what the Visa Waiver Program actually is from a legal standpoint. Second, the specific right you unknowingly waived the moment you entered the United States under Este. Third, the 2 legal traps that are currently putting VWP overstayers at serious risk. And fourth, the legal protections that exist and the precise steps you need to take to make use of them. If you have a family member who entered the U.S. on ESTA and is still here, please share this with them now. This is not content to save for later. What the Visa Waiver Program actually is. Let's start at the beginning, because context matters here. The Visa Waiver Program, commonly accessed through the ESTA online authorization system, allows citizens of approximately 39 participating countries to travel to the United States for tourism or business purposes without obtaining a traditional visa. Countries in this program include Germany, France, Japan, South Korea, the United Kingdom, Australia, and others. The process appears simple. You apply online, pay a modest fee, receive approval, and travel. At the port of entry, a Customs and Border Protection officer reviews your passport, and you're admitted for up to 90 days. No embassy appointment, no visa interview, no lengthy application process. What most people don't fully register, because it's buried in fine print that almost no one reads carefully, is that by entering under the Visa Waiver Program, you formally waived a foundational legal right. INA Section 217, the federal statute governing the Visa Waiver Program, states explicitly that by entering under the VWP, a traveler waives any right to contest removal, except on the basis of an asylum application. Let me put that in plain terms. The right you gave up. If you entered the United States on a standard B1 or B2 tourist visa and you overstay that visa, you have procedural rights under the immigration system. If enforcement action is initiated, you're entitled to appear before an immigration judge. You can retain legal counsel. You can request continuances. The process can extend over years while your case works through immigration court. That is due process functioning as most people assume it does. If you entered under ESTA and the Visa Waiver Program, that framework does not apply to you. VWP overstayers are subject to what is called administrative removal, a fast-track enforcement mechanism that does not require a hearing before an immigration judge. It does not require a court order. It does not require your attorney to be notified or present. ICE officers can process and execute the removal internally. A person can be placed on a return flight within approximately 48 hours of being apprehended. This is not a policy interpretation or an unofficial practice. This is the direct legal consequence of INA Section 217, the statute you agreed to when you used ESTA. The two traps currently affecting VWP overstayers. Understanding the law is one thing. Understanding how people get caught off guard by it is another. Here are two specific scenarios that are causing serious harm right now. Trap 1. Assuming you have court rights. You don't have. When ICE enforcement begins, the natural instinct is to reach out for help. Someone in your network may have gone through an immigration situation before. They may tell you not to worry, that you'll get a court date, that the backlog is years long, that you have time. That advice may be accurate for someone who entered on a B1 or B2 visa. It is not accurate for someone who entered on ESTA. The two situations are governed by entirely different legal provisions. If you are a VWP overstayer waiting for an immigration court hearing that isn't coming, ICE may be processing your administrative removal simultaneously. By the time that reality becomes clear, it may be too late to take protective action. Trap 2. Believing a last-minute marriage will halt removal. This is a misconception that causes enormous harm, and it's important to address it directly. If ICE has initiated administrative removal proceedings against a VWP overstayer, and that person then quickly marries a U.S. citizen and files an I-130 petition, that petition does not automatically stop or suspend the removal process. An I-130 is the beginning of an immigration benefits process. It is a petition, not a protection order. ICE is not legally required under the VWP administrative removal framework to pause enforcement simply because a petition has been filed. The removal can proceed. The individual can be deported while their U.S. citizen spouse continues filing paperwork on their behalf from abroad. The marriage route is not without value, but timing is everything, and we'll address that shortly. The legal protections that actually exist. Despite the limitations of the VWP framework, there are two meaningful legal shields available to those who understand them and act appropriately. Shield 1, the asylum exception. INA Section 217b(2) contains the one explicit statutory exception to the VWP waiver of rights, an asylum claim based on credible fear of persecution. In practical terms, if a VWP overstayer is apprehended by ICE and expresses a credible fear of persecution if returned to their home country, ICE is legally required to pause the administrative removal process. The individual must be referred to an asylum officer for a credible fear interview. That interview becomes the legal foothold that prevents immediate deportation. It's essential to be clear about what this means and what it doesn't. Expressing a desire for asylum is not a strategy or a delay tactic. It is a serious legal claim with a defined standard. To qualify, a person must demonstrate a genuine, credible fear of persecution based on race, religion, nationality, political opinion, or membership in a particular social group. If that fear is real and substantiated, it is your legal right to assert it, and the law requires that it be properly evaluated before removal can proceed. Shield 2, the proactive I-485 strategy. This protection applies to VWP overstayers who have an immediate qualifying family relationship with a U.S. citizen, a spouse, parent, or adult child. Earlier, we addressed why filing for marriage protection after ICE apprehension is largely ineffective. Here is what changes the outcome entirely: timing. If a VWP overstayer who is an immediate relative of a U.S. citizen formally files Form I-485, the application to adjust status to lawful permanent residence, before ICE initiates enforcement action, the legal dynamic shifts. USCIS policy guidance indicates that an unexecuted removal order against a VWP overstayer does not necessarily prevent USCIS from adjudicating an immediate relative's green card application, provided that application was filed prior to ICE enforcement. In plain terms, filing before enforcement begins transfers jurisdiction over your case from ICE, an agency focused on removal, to USCIS, an agency focused on processing immigration benefits. That is a fundamentally different position to be in. This is not a guaranteed outcome. The process still requires a qualified immigration attorney and carries its own complexities, but the window to act is open until the moment enforcement begins, which means the time to consult an attorney is not when you hear a knock at the door. It is now. Your action plan, 4 concrete steps. Here at U.S. Green Card Signal, we don't just explain the problem. We give you the steps to address it. Step 1. Determine your entry method. Locate your passport or check your I-94 record through the official U.S. Customs and Border Protection website at cbp.gov. Confirm exactly how you entered the United States. Did your entry document reflect ESTA or Visa Waiver Program authorization? Or did you hold an actual visa, such as a B1 or B2? This single answer defines your entire legal position. Step 2. If you entered under ESTA and remain past 90 days, consult an immigration attorney. This week, not next month. This week, the I-485 proactive strategy only functions before ICE acts. Every day without action reduces the available window. Step 3. Know what to say and do if ICE comes to you. If officers come to your door, do not open it. Through the closed door, you may ask, do you have a judicial warrant signed by a federal judge? An ICE administrative warrant does not legally compel you to open your door. If you are apprehended, whether at your residence or elsewhere, state clearly, I am invoking my right to remain silent. I want to speak to an attorney. Do not answer questions about when you arrived, how you entered, or what your current status is. If officers indicate you are being deported and you have a genuine fear of persecution if returned to your home country, state clearly and audibly, I have a credible fear of persecution if I am returned to my country. I am requesting a credible fear interview. Ensure it is stated clearly enough to be heard and documented. Step 4. Understand the legal consequences of inaction. Under INA Section 212A, 9A, a formal removal through the administrative removal process triggers an automatic 10-year bar on re-entering the United States. Additionally, the individual permanently loses eligibility to use ESTA or the Visa Waiver Program for any future travel. A 10-year bar plus a lifetime ESTA ban. That is the legal cost of being unprepared. A direct word. Before we close, knowing your legal rights does not make you someone who is trying to circumvent the system. It makes you someone who is prepared to engage with the system correctly. Immigration enforcement officers are trained professionals operating within a legal framework. The only effective response to that is to be equally informed about the laws that govern your situation. Preparation is not obstruction. It is your right. What to do? Right now. Before you close this video, here are 3 immediate actions to take. First, share this video with your family and community networks right now. There are people in your circle who entered the United States on ESTA and believe their situation is identical to someone who entered on a standard tourist visa. It is not. They need this information before enforcement explains it to them. Second, follow U.S. Green Card Signal for ongoing updates. When USCIS, ICE, or CBP makes a policy change, our goal is to get you that information quickly and accurately, not after it's already been widely reported. Stay connected to U.S. Green Card Signal so you're never behind on developments that could directly affect your status. Third, if this video helped clarify something important, engage with it so this information reaches more people. There are individuals navigating this situation right now who don't yet know which legal category applies to them. That knowledge gap has real consequences. The legal framework governing VWP overstayers is real. It is already being applied. But now you understand it. And understanding the law is the most durable protection available to you. I'm Edward from US Green Card Signal. Stay informed, stay protected, and we'll see you in the next one. This video is intended for general educational and informational purposes only. It does not constitute legal advice and does not create an attorney-client relationship. Immigration law is complex and fact-specific. Please consult a qualified, licensed immigration attorney for guidance specific to your individual situation.